approaching on the Matthew Gomez case, and Judge, he's here and it's on your bond docket, but there's a BVR issue. I've talked with the state about it. Talk to them about what I think are some interesting issues, kind of by way of background in our case. And the state had previously offered, though we had not yet gotten the contract, to do a 90-day mental health PTI, which we felt was appropriate. They're going to review with the felony court to determine whether they still believe that may be appropriate, but they can't do that at the moment. They're going to have to get some feedback and find out a little bit more information about the new felony charge. I read the cases and think there's issues with both of the cases. But there is the pending BVR based on having picked up.
Okay, pause. Did you catch that? The judge just called him up while the defense is already signaling issues with the stop that led to a felony. This is where things get spicy, because if the initial stop was unlawful, everything that follows might be fruit of the poisonous tree, legally inadmissible. Keep that in mind.
The new felony charge and need to.
Is he here?
Yes, he's here.
Come up.
I call him up.
Please.
And it's not really our issue to delve into, but I think there's issues with the way the police officers maybe made the stop in the new case. And
If he's picked up a felony offense, I'm very upset.
we understand. And
Let me express my disappointment with you, Mr. Gomez. You picked up a felony assault of a peace officer while you're on bond for this case. What happened, please?
So in the felony, the officer dispatched to a suspicious person call at a closed gas station. They observed the defendant walking around the vacant lot holding 2 glass bottles of Corona beer, indicating possible intoxication. They attempted to stop and identify the defendant, but he ignored commands and walked away towards the main road. And despite multiple warnings, he refused to comply, and he threw a glass bottle at an officer before fleeing on foot. Officers pursued the defendant for half a mile before detaining him, and while being transferred between patrol units, the defendant had already moved his hand restraints to the front of his body, and the officer attempted to reposition the restraints behind him. That's when the defendant pulled.
Whoa, bond revocation is now on the table. Let's break this down. The court is debating whether the defendant's new charge automatically violates bond terms, or whether due process still has to play out. Question for you. Should someone accused but not convicted of a new crime lose their liberty again? Sound off in the comments. Fair or not?
Pulled away and struck the officer's left thumb with his elbow, causing pain, redness, and tenderness. And then the defendant attempted to flee again, but was taken to the ground.
And I think there's issues with walking up and saying, we see someone and no more. Well,
It's
I know
not our case to litigate.
Well, I know.
All I know is that you've now picked up a felony case. Where'd you going? I got to take him.
Well, Judge, well, if we're going to be revoking him on that, then I do think it is our issue to delve into. And I think there's issues with the way he stopped. And, but if that's going to be the basis to revoke him, then this court doesn't. But the entirety of the information that the officers receive is based on what I would contend is an illegal stop. You can't just walk up and say, without more, there's no
Go
reason.
up to a guy and say, hey, let's talk.
No, that's not what they said. They said, walked up and said, show me your ID. And that's an illegal detention. That is a detention, and it's one that's unlawful under the circumstances.
I don't know.
Well, I'd like to set it for a hearing if we're going to do that.
Sure.
And he posted bond, $10,000 in the felony case. We think that's sufficient to ensure that he appears for a hearing, a formal hearing on it, without needing to take him into custody. I've talked with his mother. His mother has had good contact with me throughout this process, and she'll ensure that he's here. I think if we set it for early next week, then we can delve more into the felony case and figure out if the mental health, and I think the state can get an answer about whether mental health treatment is what's appropriate. We think it's appropriate, and even if you delve into the background of our case, the allegation is that he called the police himself and said, hey, I've got traffic tickets, come arrest me, come to my home and arrest me. An allegation, well, and that he also said, and when you get here, I'd like to be in a fight. And when the cops arrive, they oblige him, they put their tasers away and fight him. And that's consensual conduct. And whether we like it or not, humans have the ability to consent in physical fights if they like in Texas. And it may not be something that we would do or agree with, but legally people are entitled to do that. And so he's not resisting arrest even in our case. So we think there's issues in our case, but we thought on the defense side that it may be more appropriate to go the Harris Center route and see if mental health PTI.
Drama alert. The defense is going full courtroom warrior mode here. They're arguing that the new allegations don't meet evidentiary standards for revocation. This is textbook, Due Process 101, and the judge not having it. But this clash is exactly what makes courtrooms so electrifying.
I appreciate your argument. I appreciate your tenacity, but I have to be fair to every single person that comes through here. We have certain standards and procedures that we follow.
Sure.
When anyone picks up a felony case, especially a violent felony case, we revoke the bond and we put them in custody. We cannot continue to act in this manner. We are a civilized society and actions have consequences. I'm happy to give you a hearing, but no, I'm taking you into custody. You picked up a felony assault of a peace officer.
Judge, and my position respectfully is if he's entitled to, Judge, maybe before he be taken away, we finish this portion of the hearing. I think he's entitled to be president. But we think it also a part of due process that before a revocation occur, that you're entitled to both notice and an opportunity to be heard. And if they're going to be seeking to revoke his bond, then under our rules of evidence, it's very clear in Rules of Evidence 101 that a revocation, the rules of evidence apply. And everything that's gone on this morning is a proffer by the state, and I respect the proffer, but that doesn't meet the standard for the rules of evidence. And that's why
The judge found that there was enough probable cause for a felony office to be filed against him.
Sure.
I
and
don't want to relitigate a felony case here in misdemeanor court.
and I think
So-
that's fine. Well, but I think we're entitled to if we're going to be, and that's what the hearing would be for. But that
One of the
finding,
conditions of his bond is not to pick up any new cases. He's picked up a new case.
and as an evidentiary matter, there's been no presentation that he violated the conditions of bond. I know that you can look in your system and even take judicial notice of that court's finding, but that finding and pleadings that charging him with a new crime, those are not self-proving. And if they're not self-proving, then there's no actual evidence that's been presented. And we'd be entitled to ask questions to prove up, for instance, that they illegally stopped him. There's no basis for that detention. And so respectfully, I'd like to say,
Not going to relitigate the felony case. I'm not going to. You know, I respect your position, but I'm not going to.
well,
He violated a condition of his bond.
says who?
Says a felony court magistrate that put on the case again. That
He's entitled to be
filed it.
heard on that. And
And he did in felony court.
I don't believe that that's,
He goes in front of a magistrate. He has a defense lawyer in the magistrate, you know, when they do the magistration. So he does.
well, I think he's entitled to be heard here. If you're going to revoke his bond, I think he's entitled to be heard here. And that hasn't happened. And certainly hasn't happened in accordance with the rules of evidence.
Your Honor, I would just say that, just reiterate that a district court has found probable cause in this case. To say there's no evidence that he violated condition of bond is flat out wrong, because a district court judge has found probable cause on this bond. She is picked up.
And that's not self-proving. Otherwise, in trial, they could just come in and bring in that piece of paper that finds probable cause and submit that as evidence, and they can't. That's not evidence. Those are not self-proving findings.
We're not in a trial here,
Well,
right?
Well,
You know,
no, I know it's
this is
not.
just, we're having a bond hearing.
Sure.
He's violated the condition of his bond. I understand that you don't like it. I appreciate your tenacity, but
Disagree with you.
okay, and reasonable minds can differ, but he's picked up a felony case and there's a certain process that we follow.
Well, and so we'd like a hearing on that.
Yes, I will give you a hearing. Yes, but I'm taking him into custody because he's revoked it. And he's a danger to the community. I find by clear and convincing evidence, he refuses to comply with his conditions of bond. Goes with you. I'm sorry, Brian, but I mean, really,
Well,
every case, when they come in here and they pick up a new case,
I
it's
respect,
just especially a felony assault of a peace
I
officer,
understand.
you know?
I just believe that it puts the cart before the horse to make the decision to revoke based on pleadings when case law is abundantly clear that pleadings themselves are not self-proving and that the rules of evidence apply in a revocation proceeding. It's in Rule of Evidence 101, I believe. And nothing that has taken place this morning has been in accordance with the rules of evidence. I understand the court's, I understand that as a historical matter, folks come in and proffer information and I proffer information and we don't do it from an evidentiary standpoint. And that may be what the hearing would serve to accomplish. And so if the court's position is after a hearing, you'll revisit the issue about whether to reach a final decision to revoke his bond or not, then we can respect that.
Sure,
The-
happy to do it.
Okay. And in the meantime, I guess I do need to request that the bond, a new bond be set in an amount that he can.
Of course, yes.
In the event that his family elects to get him out before the hearing. And in light of our discussion.
What I normally do in these types of cases, I always set it at 5,001. Okay? If you reach out to the family and they have a problem, then we can talk about it.
Well, and I'll let the court know, the bond was set at 40,000 in the felony case and reduced to 10,000 because the family doesn't have a bunch of resources. His mother has worked to get him out on bond on that case and is going to have to do the same here, but it's really money that's coming out of the mother's pocket. And so which my whole position was get him access to resources. Now we're diminishing resources, and I respect that. I understand, but it's the mother's resources, not his. And so, and the mother, and we knew that
And I hope-
this issue was coming up this morning, and he showed up. And that's part of the goal, is to ensure that he appears, and he did, and to ensure the safety of the community. And I think that part of the finding will address the hearing. But I've been.
What do you want as far as the bond?
Well, I'd like it to be at 2,500. And
Say,
Statement already for 5,000, 5,000.
okay, when I have this kind of issue, I always split the puppy. So I'll set it at 3,750. Okay? If there's still an issue, come back and we can talk.
yes,
But there has to be a sufficient so that he understands, right?
well, and part of the discussion was, do you really get to that point of understanding if, for instance, the allegation, even underlying our case, is you call the police and say, come arrest me, I've got warrants, supposedly telling on yourself. But when you get here, I'd like to engage in a fight. And then they come and oblige him. I don't know that that's even resisting arrest. And so,
Well, it seems like to me that he's just trying to take off the whole time. He's trying to physically, or he's evading the entire time.
No, I think it's
When he
case two.
throws something at
that's
the
the felony
officers.
charge. I'm talking about our underlying.
Oh, our case. Okay, I'm sorry.
And I think probable cause had been heard before I even got appointed on that case. But I think even revisiting those facts, I've talked with the state at length over the course of settings. And my position is, if you invite someone to a fight and they say, sure, we'll engage in a fight.
If you want to set this for a formal probable cause hearing on the resisting, I'm happy to do
Well,
it.
we may address it at the same time we do the bond hearing on the same
Okay,
case.
I'm
If
happy to
that's
do it.
appropriate.
Absolutely. I'm always willing to revisit probable cause,
Yeah,
always,
I know.
at any time, whenever. So just if you want to set it for 3 days, we can have a formal probable cause hearing on the resisting. I'm happy to do it.
It may give the state a chance to find out what felony's position would overall
Right, and
be.
that's safe, but I don't want to litigate the felony. I wouldn't think that's proper. I understand they're entitled to a hearing, but a district court judge is not probable cause on this. I'm not going to be in a position to litigate the felony down.
Let's set it for 3 days,
Yes.
set it for the hearing. Let's do probable cause as well on the resisting, and then we'll come back and be ready. And then if you can show me that there's no probable cause, I'll find no probable cause, then we're done. That's it.
I appreciate it as always, Jim.
Absolutely.
Thank you. Thank you.
Brian, you had one more.
Mr. Ladon, you are on bond for a terroristic threat. You've now picked up a criminal mischief. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 11th, 2025, the officer responded to a physical disturbance at a residence in Harris County, Texas. Dispatch advised that the caller was reporting he had a knife and was going to stab someone because they were bothering him about a broken window. The officer made contact with the defendant and the complainant, and the defendant stated he called the officer. The defendant was found to be in possession of a green stuffed animal which had a fixed blade kitchen knife concealed inside. The defendant stated the complainant came to his house with her roommate accusing him of breaking a window at her apartment.
Well, hold, you're going really fast.
Yes, Judge.
The defendant,
Called the officer.
okay,
And he said that the complainant had come to his house with her roommate, accusing him of breaking a window at her apartment. The defendant stated he was walking back to his apartment and that the complainant came out the back door to her apartment, But then he changed the story saying that she came out the front door to of her apartment to confront him. The complainant stated that the defendant stated that the complainant came with a gun, though he did not see the gun. The complainant stated that she was laying in bed, heard a glass window in the back door break, jumped up, ran to the back door, and saw the defendant walking away from the door, holding a green stuffed animal with a knife. Apartment management stated the cost to repair the window was $200.
There's a lot of randomness in it, Judge.
The only thing, my concern is who broke the window? Did he break the window?
And Your Honor, so according to the DMs, what the complainant says that she saw him walking away. She heard the broken window. She came downstairs and saw him walking away. And then that's what we have in the DMs. Then I spoke with her yesterday as well. And she repeated the same thing, that he was the only one there when the window was broken. And that's what she said. She saw him outside the window door when it was broken.
He's walking away. He actually calls the police because he's being harassed by this woman because she's saying that he broke a window. And I don't think there's any list of physical evidence like glass on him or anything, or in the whatever stuffed animal.
At what point did the cops come and did they arrest him on the spot? What, do we have any other physical evidence? Do they?
We have the two further, the complainant said that he was approximately 20 feet away from the back door when she saw him, and that the officer found the window to be shattered. And then the complainant showed the back door to her apartment.
How do we know he did it?
No one's saying that he did.
I mean, no one saw, it's.
To be honest, just what we have is that the window was broken, and then she saw him outside at the time when she came downstairs to check out. That's what we have.
I get it. I
Yes,
get it.
Judge.
I don't think it's enough. However, the fact is, we're still having issues with the same complaining witness. I now have to take more drastic action to ensure nothing happens in the future. So now what I'm going to do is I'm putting an ankle monitor on it and I'm barring him from going within 500 feet of where she lives or where she works.
Yes, Judge. Ankle monitor, just want to make sure it's ELM and not scram.
Correct.
Acid fees be waived. Okay. I'll add.
How far do they live from each other, Alex?
Do you have those in the complex?
It was described as across the street. But when I spoke to the complainant, she said that they do not live across the street, that he was staying at a friend's house. But he told officers that she lives across the street.
So what I'm doing, Mr. Franklin, is I'm going to put a monitor on your ankle and there is a radius of where you cannot go where this person lives or works. And I mean, we may have issues with bond conditions as it is, because if I ordered him not to have weapons on the terroristic threat and they show me that, or they prove to me that you have weapons, I'm going to put your butt in jail. So maybe we should have a formal bond hearing to see if in fact you can prove that he has a weapon.
Yeah, Judge.
So I have some hesitancy about everything, Judge, mostly because my client's orange sheet is quite extensive. So the jail has diagnosed multiple mental illnesses. I'm trying to track down his competency because I was appointed, I think, December. So there's been prior competency motions. I'm trying to get the reports from them, which is difficult because I forget what agency does the mental health evaluations. They're saying that they don't exist. So I'm trying to find his mental health records, Judge. It sounds to me like it's bipolar schizophrenia or schizoaffective. And so I think that my client is likely going to have severe mental health issues, which have been causing issues. And I think that's going to be the heart of all this. And so I'm trying to push for treatment. The case is just brand new is the problem.
You ordered not to be in possession of any weapons. And they're telling me now that you have a new case and that you have an alleged knife as well. I want to set this for a formal hearing on Monday. And if they show me that you have a weapon in violation of your bond conditions, I'm going to bring it. Do you understand? You are not to be in possession of any weapons whatsoever. Get a hold of your witnesses, get a hold of the cop.
Yes.
Let's have a formal hearing on Monday to show me whether he's in possession of a weapon or not.
Yes, Judge.
Yes, Judge.
In the meantime, like I said, if I find that you become a danger to my community, it's really not going to go well for you. Do you understand, Mr. Franklin? There is no excuse. You will get this ankle monitor today, and you're not to go within 500 feet of where this complaining witness lives or works.
If I can politely ask Judge that we reset for more than Monday, only because this case is new enough that there's literally no offense report. So I don't know officers' names or,
Case.
so the new case, the criminal mischief, which will be the allegation for the motion to.
Find no probable cause in the criminal mischief.
Well, but the problem is, Your Honor, is that it's on the criminal mischief that we have the officer that saw the alleged knife. So we'd have to get in contact. We don't have the OR. We have the name. I could reach out, but we don't have the OR to give defense. So they can review it. And
So the allegation is, and it's, we don't have an OR, so we're reading DIMS. So the allegation sounds like the officer saw a knife, or maybe the CW saw a knife. It's unclear.
To me, it sounded like both saw a
Yeah.
knife. And so
Well,
that's why.
I don't know
So,
if
I
anybody
mean,
did.
I guess I'll give you a full week. You know, that should be sufficient for you to get an
Yes.
OR,
Yes,
get
sir.
in contact
Because-
with both witnesses.
just to clarify for both parties here, the officer is the one that said when he contacted him, he found the defendant in possession of the knife.
Okay, let's have a hearing.
Yes, Judge.
Get this guy over here. If you need to subpoena him, do it. So that in today's Wednesday, we'll have a hearing next Wednesday.
Thank you, Judge.
All right. Good morning.
Hey,
How are you?
hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay?
It's stuff that we right back there. She's gonna read it again, okay?
Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle in the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued
it.
to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
Just losing?
Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then
Right, but then cops get up there.
themselves, and then they observed him begin to walk away. And it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know
says
about that?
and
Yes,
aggressive
Judge.
behavior.
But
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. "I smell marijuana. You look intoxicated," because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is We identified ourselves as police. So what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey,
So-
I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
Criminal trespass.
they're called, yes, a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So
signs.
the trespass investigation ceases because he's leaving. Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is?
Okay.
The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
he's
He's
walking.
leaving, right? It's like, here, let me come and mess with you more,
That would only,
right? So it's like adding fuel to a fire.
but they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw, him refusing to leave, and
He leaves.
he only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't be, it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturb, we don't always specify the disturbance.
I'm gonna find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we? You don't like to wear orange, do you? Be careful where you go. Be careful what you do. Everyone's always out to get you, man. Don't let them. All right, man. Good luck.
Thank you.
Unless you.
You were Mr. Jefferson. Mr. Jefferson, you're charged with 2 cases. You're charged with harassment. You're also charged with terroristic threat of a family or household member. On the terroristic threat, you're facing up to a year in jail and or a $4,000 fine. On the harassment, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Okay, pause on which one, Your Honor?
Are they one and the same?
They're not out of the same transaction, Your Honor.
Okay. I guess start on the harassment, which is the earlier one.
Yes, Judge. On October 15th, 2024, the officer met with the complainant at her residence in Harris County, Texas, regarding a terroristic threat call. The complainant advised the defendant is her ex-boyfriend, who she was living with until April 2024, when she decided to move out. The complainant stated she received a photo of the defendant with a firearm to his head, and after the complainant blocked the defendant, she started receiving multiple emails from him asking for half the rent. When the complainant refused, the defendant sent her a message via email saying, "If I lose this place, I have nothing to lose after that, so I'll be sure to put you there, and that I promise." The complainant went to work and she advised the defendant was at her job and refused to leave despite her requests and stayed outside in his motor vehicle. And then, would you like to hear that?
So the harassment is the text, I'm assuming?
The harassment is the multiple emails, including the message via email saying that the threat.
Okay. All right, go for the terroristic threat. Same complaining witness?
Check, Your Honor. Yes, Judge.
Okay.
So for the terroristic threat, on January 2nd, 2025, the officer was dispatched to the residence in Harris County, Texas, in reference to a terroristic threat call. The officer met with the complainant, who stated the defendant messaged her stating she paid her portion of the light bill and the complainant needed to come and pay the other portion. The defendant messaged her twice on TikTok saying the same thing, and the complainant stated via TikTok, if the bill was not paid by the 4th, there will be problems. The complainant received additional messages from a TikTok account with the username account not found, meaning the account was deleted or disabled. And the account stated, I tried to be respectful. I promise you, if it is not paid, I will put your social security number and personal information on the internet and I will shoot up that house, starting with your bedroom. The complainant stated she is in fear for her life.
Is there any kind of immediacy to this thing? Do the covers back. The stickers. Stems.
Your Honor, he specified that prior that if it's not paid by the 4th, there will be problems. And then he's again repeating that state, if it's not paid, that he will shoot up the house. The threat would be, I will shoot up the house.
There's no contingency in a terroristic threat. It's a threat. Here you have an act that's contingent on something else, right? That's not, no. All right, so Mr. Jefferson, I'm going to find there's no probable cause on terroristic threat. However, I am going to find that there's probable cause to go forward on harassment. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand?
Yes.
You are also not to be in possession of weapons. If I find that you become a danger to our community, I have one place for you. I will revoke your bond, put you in jail, no more PR bonds. You missed court yesterday. We issued a warrant. I will reinstate your bond today, but this is the only get out of jail free card you get. You miss court again, I will revoke your bond, no more. Do you understand?
Sorry.
It is your responsibility to know when to come to court and when to show up. We have given you a lawyer. It is also your responsibility to stay in touch with the lawyer. If he tells me he can't get a hold of you because you're ducking and dodging, likewise, I have one place for you. Do you understand?
Sorry.
So can you file no contact, no weapons, please?
Yes, Judge.
On the harassment.
Yes, Judge.
So what we're going to do now is I'm going to have you sign a reset with Victoria. We'll have you take a seat in the jury box. Do not leave until you sign our bond conditions, then we'll wait for your lawyer to show up.
Judge is approaching again on Mr. Jefferson. The state is asking for his next appearance to be required so they can serve him with a civil protective order out of the 280th. I would ask for his appearance to
How's
be.
that going to work?
Yeah, so Your Honor, in this case, the complainant through our office is applying for a protective order. So we're just asking for his appearance to be required just so we can serve him the protective order and then the civil division will take it from there.
I would object just for inconveniencing him, Judge, and don't they usually just have a deputy come out to your house and serve you?
I don't know. I mean, I've never done the 280th domestic violence to where I don't know. I mean,
I've encountered them a few times, but I've never dealt with the process of my clients being served them. They just get served.
so so you apply, you've got the hearing, you have to serve him so that way he can go to the hearing in the event that he wants to
Your Honor, And
contest.
that's all we want to do is get
Right.
the process started so we can protect our complainant in the case. And we would have had him served today, Judge. I just don't believe that things have been,
Want me to do a protective order now?
no, because this is the long-term civil protective order, not just the MOAB, Your Honor.
And they already have a no contact.
We do, I believe, have a MOAB on file.
You want me to
in the
put a
case.
MOAB in now?
Sorry?
You want me to did I already do a
In
MOAB?
Yeah, I
the
thought
ad-
you did.
I believe we do have a MOAB in this, well,
No.
in the prior case we do, in the new case,
No, that wasn't signed.
Let me,
we just-
in one for
yeah,
now,
yes.
because I know that he has the harassment, he has the other terroristic threat. I didn't realize that you guys had filed it.
Judge, he doesn't live with the complainant. They share no children together. He has no problem staying away from her.
Mr. Jefferson, come up. Mr. Jefferson, on your harassment case, I'm entering in what's called a magistrate's order for emergency protection that identifies Ms. Green as a protected individual. As of this day forth, she's now protected, meaning that you cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this court order in any way, the state can and probably will file a violation of a protective order against you. It's one of the worst cases you can pick up. Do you understand?
Yes, sir.
So I'm going to have you sign this now. The state's asking me to have you come back so you can be served, but I don't do that in any case. And I don't want to show preferential treatment for you guys, you know, like I would show preferential treatment to them, because unless I know that the person is a flight risk or homeless to where we know we're not going to get a hold of them, I normally waive on everybody. And I can't, it wouldn't be fair for me to show preferential treatment to have him come
Your Honor,
back,
we
you
just
know?
had to ask.
So will acquiesce in in granting a protective order now, but so what I'm going to do is I'm waiving your appearance so that you don't have to come back and waste your time in court here. But you must stay in touch with Mr. Sims. And if he tells me he can't get a hold of you, then I'm going to issue a warrant for your arrest. No more PR bonds. Do you understand?
Yes, sir.
So if you start to become a problem out there in the free world, I will take the free world away from you. No more PR bonds. You pick up a new case, no more PR bonds. You start harassing, no more PR bonds. I'm not asking for much. All I want you to do is stay away. There are a gajillion and one fish out there in the sea. It's not worth throwing your life away. You understand what I mean?
Yes, sir.
Life is way too short to live in a 6x9 box. Jail sucks. It's not fun. All right. I'll have you sign the protective order and then we'll get you guys out of here.
Thank you, Judge.
Thanks.